Welcome back. You're watching The Firm. Now for the other big story of the week. 14 car manufacturers and a 2,544 crore rupee penalty. The Competition Commission of India has found all 14 guilty of anti-competitive practices in the auto spare parts industry. Besides the impact on the business model of car manufacturers, the order also lays down important precedents on contractual freedom and use of IPR by dominant entities. Payaswini Upadhyay gets you the how, why and what next.
Did it ever strike you that the only way to get a branded spare part for a Honda, Volkswagen or Fiat car is to go to an authorized dealer? Because an independent repairer may not have access to the branded spare part or the technical know-how pertinent to that brand. One Shamsher Kataria in Delhi found this to be unfair and exorbitant. And so, he complained to the Competition Commission of India that these three companies are restricting the availability of spare parts and after-sales services. The CCI saw merit in the complaint and ordered an investigation not just against Honda, Volkswagen and Fiat, but 11 other car giants. This week, the CCI found the 14 car companies guilty on 2 counts. 1. Entering into anti-competitive agreements with their suppliers, and 2. Abusing their dominant position.
This is the first time where the competition regulator has gone to the extent of scrutinizing the vertical agreements, although there are some instances where they have gone into looking into the vertical agreements. But this is a straight case where one player in one sector, like in the car manufacturer, has got direct control over the equipment manufacturers, and they are actually guiding whether to be sold through the service providers or to the customers of the car manufacturers. This certainly gives a guidance to us that the CCI in future will be looking for these kind of the contacts or combinations through a vertical arrangement where one party is completely dependent on the other party, and whether there are those kind of agreements and a conduct can be treated as anti-competitive.
In this case, the CCI concluded that the agreements were in fact anti-competitive. The car companies argued that they sign agreements with suppliers to ensure quality and protect their goodwill. Some among the 14 manufacturers also argued that the competition law gives them protection against infringement, and so, if they are asking suppliers to seek prior consent before selling spare parts to third parties, that condition is a reasonable one. The arguments did not find favor with the regulator. The CCI noted that nothing prevents the car companies from ensuring that their suppliers stick to the same standards of safety checks and use such labels on the spare parts that protect the brand image of the car manufacturer and limit their liability. As for the IPR argument, the regulator concluded that since the owner of IPRs is the foreign parent, the exemption provided by law cannot be availed. The exemption is contained in Section 3(5) of the Act that allows companies to sign agreements to protect their intellectual property rights.
The CCI says that the car companies have not been able to furnish evidence that in India they have the protection of these rights, and therefore they do not have the protection of Section 3(5) of the Act. That is what the CCI has said. The second thing which they said with reference to IPR is that Section 4, which is abuse of dominance, that section gives no protection for IPRs similar to Section 3, and therefore an abuse of dominance, which to my mind was the main argument of the CCI. There is no protection, and therefore they rejected this argument relating to IPRs.
Looking at the global jurisprudence, I think the CCI certainly should respect that if anybody who is sitting out of India, and especially light on the fact that our Act has got cross-border jurisdiction, so therefore if somebody is having a right or protection offered under any other law in any other country, and that is also registrable in India under the Indian law, although not registered, those kind of rights should be taken into account, and that protection offered under those laws should also be given cognizance of. That's what my take on the order is.
The CCI concluded that the agreements between car manufacturers and their suppliers restricted others from providing spare parts to consumers who had no option but to head to the authorized dealers. This led to a dominant position that was being abused by the car manufacturers. A faulty engine, a broken drive shaft, a malfunctioning control unit. In any of these situations, the consumer would most likely feel forced to take the car back to the authorized dealer and pay the price determined by him. And that's why the competition regulator got worried. The fact that the consumers get logged in with car manufacturers for spare parts and services. To determine abuse of dominance, the CCI divided the market into two. The primary market, that is, manufacture and sale of passenger vehicles, and two, the secondary or after-sales market, that is, spare parts and sales services. And the regulator decided that the secondary market is the relevant market. The companies argued that both should be combined to determine the relevant market. The argument was rejected by the CCI. The regulator relied upon several US judgments and studies to conclude that consumers rarely take into account the cost of after-sales services when buying a car. Manufacturers exploit this by selling cars cheap but charging exorbitantly for after-sales services. For both to be considered as one market, buyers would have to know at the time of purchase what their after-sales cost would be, which they don't, and hence the after-sales services market is a distinct market.
CCI has relied upon certain old empirical studies done by economists in 1970s, late 70s and early 80s in the US. And it has therefore decided to use those conclusions in the Indian context. Now the Indian market and the US automobile markets are quite different, and therefore I am not sure whether that will squarely apply here, and only on the basis of those empirical research the claim of the auto manufacturers that it is a systems market can be rejected. It really remains a debatable issue, and there should therefore be an opportunity for the car manufacturers to challenge this in the appellate tribunal.
Having determined the after-sales services market as the distinct market, the CCI narrowed it further that after-sales services market of each manufacturer is the relevant market to ascertain dominance. The manufacturer is dominant in that market because it's the sole supplier of spare parts and diagnostic tools. This dominance, says the CCI, is then abused by 1. Denying market access to independent repairers, 2. Charging exorbitant price for spare parts from the consumers, and 3. Leveraging the dominant position in the spare parts market to control the services market.
Interestingly, while determining the dominance, the CCI has drifted away from that definition and said that dominance of, let's say, one single car manufacturer is to be seen qua the product manufactured by them or the product or branded product sold by them. Now, it has been said that they are dominant in respect with the components or branded components they are selling in the Indian market. Now, I think that's a contradiction in itself. Either the entire sales of spares and services is the one market where all the players are participating in that, or it can be said that the manufacturer specific component market is the relevant market. And I'm saying so because there cannot be a 10, 12, 15, 20 dominant player in one market. And if we agree with what CCI has said while determining the abuse, I think all the car manufacturers become a dominant player in respect with their own component manufactured and sold in India, besides the automobiles itself. So I think that's the basic flaw.
After concluding abuse of dominant position, the CCI imposed a 2,544 crore rupee penalty and several conditions on the manufacturers. For instance, make spare parts and diagnostic tools easily available, allow suppliers to sell spare parts in the open market without pricing and other restrictions, train independent repairers and not impede their operations, standardize parts to enable their use across brands, do away with conditions that result in cancellation of warranties, etc.
Some of these corrective measures are a direct consequence of what the CCI has said. CCI has said you cannot block the availability of spare parts in the open market. So it was natural to tell them that look, the opposite of what you are doing is to make that available. The independent car repairers have been saying that the spare parts are not available to us, the diagnostic tools are not available to us, and therefore we actually cannot offer service to a car owner. And therefore it was natural for the CCI to tell them that don't limit the availability of your diagnostic tools to just your authorized dealers, but in a more broad way. And I think the CCI has drawn upon the corrective actions which have been taken in Europe and other places.
I don't think a competition agency has the authority to actually even in case of a dominant enterprise to direct how it should conduct its business. Well, the intents are right, but perhaps the directions being given to implement those intents seem to have gone a little too far as far as the competition agency's normal remit is concerned.
The other flaw that experts have pointed out in the CCI's order is the calculation of penalty. The compact has laid down that the regulator should calculate penalty on relevant turnover and not total turnover. And even though the CCI has challenged this position in the Supreme Court, till such time it is overturned, experts say CCI cannot base its penalties on total turnover. The parties have 60 days to comply with the order, and any immediate appeals would have to go to the High Court, since as of now, the Competition Appellate Tribunal is non-functional. Besides the principles of competition law, this order is landmark as it has the potential to change the business models of car manufacturers and benefit consumers. If CCI prevails, consumers will have more outlets to buy spare parts and after-sales services. Something similar played out in the EU, where under the block exemption rules, manufacturers are supposed to provide spare parts to independent operators. In the US, several states have introduced the Right to Repair Act to curb restrictive practices by automobile manufacturers. Perhaps it's time now for manufacturers in India to remodel their businesses. In Mumbai, Payaswini Upadhyay.
With that, we're going to wrap up this edition of The Firm. Thanks very much for watching. We hope you have a great festive weekend, a long one at that. We'll see you next week.